Good morning and welcome to another social equity education session. My name is Angie and I am a social equity representative with the Marijuana Regulatory Agency. Thank you for joining us today for a presentation meant to inform and educate you on new changes to the rule set that you should be aware of. Today we have Lauren Fitzsimons and John Frazier from Dykema's law firm presenting a summary of the most significant changes to the rules, including discussions of new license types, policies, and procedures that prospective and current cannabis business stakeholders must familiarize themselves with. Following the presentation, they will be sticking around to answer any questions that you may have. So to keep things moving along, we highly encourage you to ask questions as they come up during the presentation. You can do this by typing them out in the Q&A box that you see on the bottom of your screen. Lauren and John, go ahead and take it away.
Great. Thanks so much for the introduction, Angie, and good morning, everyone. Let me get my PowerPoint shared. We'll start the slideshow. And I think hopefully that should be working okay. Can everybody see it okay? It's coming through. Excellent. Well, good morning, everyone. As Angie stated, my name is John Frazier. I'm the Michigan team leader of Dykema's cannabis practice. I'm also an adjunct professor of law at Cooley Law School, where I teach a course on cannabis law. And I'm joined by Lauren Fitzsimons. Lauren, do you want to introduce yourself? You don't need me to do that.
Yeah, so I am also in Dykema's Lansing office in the government policy group, and I also specialize in cannabis issues and highly regulated industries.
Great. Let's see. Is that better as far as showing my screen? Did that fix that?
Yeah, that makes it
okay. Okay, excellent. Sorry about that. Never fails on Zoom. I'm sure everybody here who's had to attend a Zoom presentation so far in the last forever and a half since the pandemic started has had somebody do a technical goof. So I'm glad we got it out of the way right away. So next slide. Great. So obviously as lawyers, we couldn't get this far without having a legal disclaimer. So here it is for you all. Obviously, you're attending this presentation because we just had a change in the rules. And so what we present on this presentation here is accurate as of March the 25th. But things change quickly. And I know this is being recorded. So if somebody watches this in the future, you've got to check and make sure that things haven't changed. We don't work for the MRA and we can't speak for their opinions. So keep that in mind here. They're just generous enough to give us a platform to speak with you all this morning. And we work at Dykema. That's a law firm. If you haven't hired us as your attorneys, that means we're not your attorneys. So we're giving you this as informational purposes only. And that's what this is at this time. So that being said, sorry for boring you with the disclaimer. Let's turn it over back to Lauren. Can we start with our first kind of really significant update here to the rules?
All right, yeah, we're starting with fee reductions. So the changes to the rules brought about lowered license fees, which has, I think, been met with absolute delight by applicants and licensees. The MRA was able to have its application fees from $6,000 to $3,000 for both medical and adult use. And the license renewal tiers were also removed for medical and adult use. However, the change for medical licensees isn't going to take effect until the fiscal year 2023. So for right now, the medical licenses are still going to be going forward with the renewal tier for this fiscal year. For adult use licenses who've already been invoiced, they're going to have to pay the renewal fee as it was invoiced, which is going to be the tier most likely at this point. But they'll be benefiting from the lower license fees next year when they renew again. And as you can see, the adult use license fees are laid out in the table on the slide here. It's a pretty significant drop from where we were at before. So I think it's a good testament to the program MRA has done that they've been able to lower those fees. And it definitely opens up the market a bit more. And for social equity applicants, the applicable discount based on your status is going to apply to these fees.
Right. So we could have folks with, 50, 60% discount, right, on some of these existing fees. So that could mean your pre-qual application fee, where it started as a base fee of $6,000, maybe coming down south of $1,500. So I'm always very happy. I imagine you are as well, Lauren, to be able to tell clients, hey, we're keeping more money in your pocket. And I know everybody is really grateful to MRA to find a way to make these fee reductions possible.
Yeah, I think it's particularly great for the social equity applicants here because it just lowers the bar to entry that much more.
Absolutely, no doubt. So let's talk next about one of our brand new license types in this new rule set. And it's one that's gotten, I think, hopefully folks excited about. And it was, I think, a recommendation out of the MRA's Racial Equity Advisory Work Group as well. And that's our Class A marijuana micro business. So I think folks are probably familiar with the micro business license that's spelled out in the MRTMA, the adult use statute. The Class A micro business has some significant upside from the quote unquote standard micro business. And essentially what it allows is double the plant count, whereas the standard micro business only allowed cultivation of up to 150 mature plants. The Class A goes to 300 mature plants. The Class A micro business can package marijuana. So you should be thinking like pre-rolls or pre-packaged flower. This is the huge change from the standard micro business license in that the Class A micro business can purchase marijuana concentrate and marijuana infused products from licensed adult use processors. And that's a really significant change from the standard micro business license that was created by the statute. The micro business license, not to be confused with the Class A, essentially operated on an island. It couldn't sell product to any other licensee, and it couldn't purchase product from any other licensed business. So the fact that the Class A micro business has the ability to bring in marijuana concentrate, marijuana infused products is a really significant and positive change, I think, in my mind, and hopefully makes this a little bit more of a commercially viable business. Just like the kind of standard micro business license as well, the Class A micro business license allows that business to be able to sell marijuana and marijuana infused products at retail to adults age 21 and up on site at their facility. So, you kind of have a cultivation and retail license all in one here, and the ability to source in marijuana concentrate and marijuana infused products. Just like every other license type, the Class A micro business has to comply with all the other same rules as other licensees, such as having their product tested by a safety compliance facility. They have to track their product in metric, etc. So, pros and cons of the Class A micro business. I imagine folks are interested in this piece as well. So from my perspective, there is a lot to be said in terms of the pros here. The Class A micro business adds a lot more flexibility than is afforded to the standard micro business license because of the ability to source marijuana concentrate and marijuana infused products from licensed processors. Because of that fact, they can offer a much wider variety of products, such as edibles, vape cartridges, concentrates, etc., without having to sacrifice biomass from their limited plant count to produce those products, right? So under the standard micro business license, because you're kind of on an island and you only have 150 plants to work with, it's probably really challenging on the standard micro business license side to offer marijuana infused products or concentrates to customers, right? You're only growing 150 plants, and you can only sell and produce, sell what you produce off those 150 plants. So, buying the equipment, the extraction equipment, or whatever you might need to make infused products is probably a difficult cost proposition when you're only working with a limited plant count. And when you only have 150 plants, that means your inventory is 100% limited by what you produce. contrast that with the Class A micro, you grow 300 plants, you could really dedicate 100% of your 300 plants to flower, right? That's really what you'd be doing. And if you want to offer infused products and concentrates to customers, you now have that option without having to bear that cost of essentially doing everything yourself. So I think that's a huge upside and something I'm very interested to see how it plays out for licensees in the future. Obviously, we talked about double the plant count. If you have more plants, that means you can produce more flower. More flower means more inventory. More inventory hopefully means more sales and a more profitable business. There's a couple downsides as well, though, that I think you ought to be aware of with the Class A micro business. The licensure fee is more expensive than a standalone retailer license. I suspect that's because you have a cultivation and a retail store mixed together. Generally speaking, construction costs for Class A micro business are going to be more expensive than a standard retailer license because the cost of building out the cultivation portion of the facility. Even with the ability to buy in marijuana infused products and concentrates from marijuana or licensed processors, Class A micros are likely to be more limited in terms of the availability of different strains of flower because you're only working with a total universe of 300 plants. That being said, I've heard from plenty of folks, you have the smaller plant count, you can really be focusing on craft cannabis, and I'll let you all tell me how good the quality is when you're growing at a smaller scale. One challenge I think to be aware of is just like the standard micro business, you're not able to sell product at wholesale, right? So whatever you bring into your business in terms of acquiring it from a licensed processor or whatever you produce in terms of flower, you can't wholesale that to another licensee. So you've got to drive your retail sales to your business. And so that could create a challenge if you have poor performing inventory in your retail store. One thing I left off of here is you would be able to, just like the standard micro business, be able to participate in marijuana temporary events. So if you're invited to participate in a temporary event, you would be able to basically set up a booth and have retail sales from your booth at that temporary event. So that was a lot. I hope it was helpful. Lauren, back to you for the changes on ownership disclosures.
All right. So yeah, we've got some changes and clarifications on ownership disclosures here. So individuals or entities with 2.5% or more interest in an applicant entity or licensee are going to have to be disclosed under the new requirements. And this really is just bringing the requirements in line with the medical program right now. And hopefully that's going to make it easier for the MRA to administer that and keep more consistency across the programs. So they also clarified that if the entity is a trust, the applicant is going to need to disclose the names and addresses of the beneficiaries. And that is a new requirement. So I think MRA probably didn't have to deal with many trusts initially, and as more people have become involved, that's an issue that's come up. So that'll be a new change for people who have trusts involved in their entities. So, and if the entity is a privately held corporation, the names and addresses of all shareholders, officers, and directors need to be provided. But if the entity is a publicly held corporation, it's still just the names and addresses of all shareholders holding a direct or indirect interest of greater than 5%. And that includes officers and directors as well that need to be disclosed.
So Lauren, we have a question I think it's a good time to answer right now is, what are your thoughts on picking a business entity type, an LLC versus a corp? And are there any considerations specific to this industry that we should keep in mind? Do you want to take a stab at that?
Well, it really depends on how you want to set up your business, I guess, and who you want to be involved. So
Yeah.
if you're having a more smaller operation where it's just a few owners and everybody's very involved, I think LLCs are a little easier, just because it's a bit simpler, but corporation definitely gives you a little more flexibility in terms of, I mean, you can have passive, I guess, investors as well with LLCs.
And I think, really the decision on business entity is one that's a conversation that you'll want to have with your CPA. A lot of those decisions on entity selection are going to be made with respect to certain tax considerations that you're going to have in mind. And what is going to be the best structure for one type of business may not be the perfect fit for how you have your business structured, or what type of license you're going to apply for, and really who's contributing capital to the business. So that's an excellent question. And it's one that you really need to bring your CPA in, or your tax advisor or tax attorney in, because there's just a lot of different factors that are going to go into play in terms of what type of entity is going to be the right fit for your business. Some of these ownership disclosure changes here have simplified that question from our perspective in terms of looking at how to structure entities for purposes of applications. And now that we've really unified things across the board to an extent, that piece has become more simple. And now I think you're really looking at tax considerations as being the driving factor.
Yeah, I would agree with that.
So let's move on and talk about another, and I think really significant and important change in these new rules, which is the requirement to, with respect to the municipal attestation. So for those who are new to this process, when we talk about the application process, there's two steps, right? There's the pre-qualification application, the general background check, essentially of the applicant entity and the folks that meet the definition of a supplemental applicant. And then the step 2 application is your actual establishment license application, where we give the who, what, when, how, why of how the business is going to operate. And prior to the new rules taking effect, part of that step 2 application required licensees to receive the signature of a municipal official in the municipality where the business was going to operate, stating that the licensee complies with all the applicable municipal ordinances. As folks may guess, getting a municipal official to sign a form sounds really easy until you actually try to track down the person that needs to sign, and it can be a real challenge. And so there was a Court of Appeals decision that called that practice into some amount of question, and that highlighted one of the statutory provisions in the MRTMA, which basically says all municipalities are opted in to allow adult use marijuana businesses unless the municipality passes an ordinance to affirmatively opt out. And the way the language in the statute is structured is that municipalities have the opportunity, once they're informed by the MRA that they've received a license application from a prospective licensee, that they have the ability to object or highlight issues that the licensee may have with the municipal ordinance. And so this new change to the rule here kind of brings the process from an application perspective in line with the statute. So now, instead of having to go chase down a municipal official to have them sign an attestation, now the licensee, the applicant, signs a municipal attestation saying, I'm in compliance with everything that's required from the municipal ordinances. The applicant provides contact information for the municipal official, and MRA will reach out to that municipality to confirm that the applicant is in compliance. So this is a huge change in my mind to really make the process much easier on applicants. And the MRA has already issued a new attestation 2C, which was the previous It's still the municipal attestation, but the new attestation 2C simplifies the process to conform it to the rules, and the renewal attestation has been updated as well. So this is a big change. Important to note that it only applies on the adult use side, does not apply on the medical side, and there's an obvious reason for that. The medical statute, the default position for all municipalities is that they don't allow marijuana businesses unless they've opted in, and the adult use side is the inverse, right? All businesses are allowed in this, the municipality opts out. So I hope that's helpful. I think it's a fabulous change. I give MRA huge props here because I can't tell you how many clients we've had really struggle getting this piece. It never fails. The clerk or whoever you need to sign is on vacation right when the facility's done. So,
oh yeah, definitely. One other thing that might be helpful to note that I've at least experienced so far with working with the MRA and some renewals is that they've set a standard amount of days for the municipality to respond when they notify the municipality, and it's 10 days. So you should make sure that you're getting your renewal in with plenty of time to for the municipality to have those 10 days before your license expires.
Right. That's an excellent point, because there's a big distinction on the renewal side on the adult use statute versus the medical statute. The medical statute has this kind of 60-day grace period past your expiration date where you can clean up anything that you may have missed by the deadline. That doesn't exist on the adult use side. So that's an excellent point, Lauren. Let's talk about changes to compliance and reporting obligations.
All right, yeah, getting into the fun stuff. So the new rules have made some additional notification requirements to MRA. One is kind of also clarifying is for a municipal violation, so that's an ordinance or zoning violation, the MRA needs to be notified within 10 calendar days. But they only need to be notified if the violation relates to activities licensed under the MMFLA or MRA. And so in practice, this is going to be like if you get a zoning violation, for an issue with your sidewalk or not cutting your grass, that's probably not what MRA is looking to find out about. They want to know if you committed to social equity requirements, or if the municipality has specific rules about how you need to do the cannabis business specifically, that you are following those rules. So the other new one is for in case of a fire. Hopefully most people don't have to experience, but MRA wants to know within 1 business day if you have a fire at your facility, and BFS also needs to be notified within 1 business day. So that is a short turnaround. So that's definitely something you are going to need to keep in mind if that happens. The other new one is the appointment of court-appointed personal representative, guardian, conservator, receiver, or trustee of the license. So I think the most likely reason for MRA doing this is it kind of changes who's in charge. So the MRA is going to want to know about this, and it looks like it didn't put the days on here, but it's 10 business days, within 10 business days of the appointment, that you need to let MRA know. So MRA has also clarified that the deadline for notifying the MRA of new legal proceedings or government investigations is going to be 10 calendar days. It was always 10 days in the rules, but they've just made it clear that it's not business days, so you don't get 2 full weeks to notify them. And the deadline for notifying MRA of criminal proceedings, civil judgments, and disciplinary action taken against the applicant or licensee is now 3 business days instead of 1. And that's probably really going to help people comply, because the 1 day turnaround is always really hard, especially when people are, they just got served something, trying to figure out what's going on. It's not always the first thing on your mind that, oh yeah, we have to notify the MRA, but that at least gives people some breathing room to get that notification in.
Absolutely. And, it's good to have some definition too, especially on the difference between where a business day or a calendar day applies. Maybe in the future, we'll just have them all be business days or calendar days so that we don't have the back and forth. But this is what we have now. And it's good that we don't have at least a gray area in between those two. So let's talk about everybody's favorite thing, maybe not, standard operating procedures. So this is a new rule in the rule set. And I think a lot of licensees were probably already complying with this obligation to some extent, because part of doing business means telling your employees how they actually need to do their jobs to make sure that the business is operating in a profitable and perhaps most importantly to this meeting, a compliant way, right? We always want to make sure our employees are discharging their job functions in a way that's not going to jeopardize the company's license, right? Y'all are going to work really hard and put a lot of time and effort into starting these businesses. So we want to make sure that license stays on board. So the new rule requires licensees to have up-to-date written standard operating procedures on site at the facility at all times that can be made available to the MRA upon request. And these SOPs must detail the marijuana business operations and activities necessary for the business to comply with the MMFLA, the medical statute, and the MRTMA and the rules. So there's a lot there that could potentially fall within that language. And if the MRA determines that a licensee's SOPs don't comply, the MRA can require the licensee to correct the practice immediately and update their written SOPs within 1 day. This language here in that third bullet point is what we have. That's the exact language from the rules. And as you could probably guess, there's a lot there that could fall within the purview of not making the business necessary to comply within these acts and the rules, right? There could be a lot of different discrete functions of the business that might require an SOP. I'm hopeful, MRA, if you're listening, that the MRA will issue some written guidance for the various license types on what specific processes they want to see written SOPs for. That would be really helpful, as opposed to businesses doing what they think is best and what meets the definition of the rule. I'm hopeful we'll get some guidance from MRA. I know our firm, and I suspect a lot of other firms, are working on lists to be able to tell clients what we think are appropriate processes and business functions that probably ought to have written SOPs. And I suspect, like the MRA has done with most other rules of this nature, that there will be a learning process and they'll work with licensees. But folks should be advised, if you don't comply with the rules, which this is now a rule, just because the rule says MRA can require a licensee to update their written SOPs within 1 day, it doesn't mean that a failure to have a written SOP couldn't still be a rule violation that could give rise to disciplinary action. So this is a very important change, and all licensees should be thinking through writing SOPs for their business and sitting down and thinking about what types of processes do we really need to document. And frankly, this is probably a good business exercise anyway, as you're working on trying to train your employees to make sure that they're doing their job functions properly. So that's SOPs. Lauren, labeling requirements, what's changed?
All right, so the MRA's gotten a little more in detail on labeling requirements. So they've added a requirement that the label has to include a product modifier that says something like marijuana product, THC product, or cannabis product, using the same or larger font than the product name. So I think a lot of these requirements too are coming from, I can't speak for the MRA, but I think a lot of them are coming from the position of they don't want anyone to be mixing up marijuana products for anything else. They want it to be abundantly clear from the packaging that this is a marijuana product. So that's what these new rules really reflect. So the ingredients list has been clarified that it needs to include excipients and diluents. The ingredients list actually, it always said all ingredients. MRA has just clarified that excipients and diluents count. So there may have been some differences in interpretation previously that they wanted to make sure everything was included. So, and if you're not clear on what those are, excipients are inactive substances like coloring agents, preservatives, and fillers. Diluents are what they sound like. They're things that dilute the product, and they include things like a medium chain triglyceride or MCT oil, propylene glycol, or ethyl alcohol. And,
you're braver than I am, because I wouldn't have tried to pronounce any of those. So
you have pronounced them before this, just to make sure. So, but yeah, so I can't give you a lot of details on exactly what those are, but I just know they dilute the product, and I'm sure people that are actually doing that have a better idea of that. So edibles cannot be packaged in a manner that can be confused with a commercially available food product. It used to just be that they can't be confused with candy. So that was more directed at children. I think children is still a very big category that MRA is concerned about. Kids finding, adults product and not knowing that, they should not be eating it. So I think this commercially available food product is probably trying to address things like, if an edible looks like Oreos or something, and, could be confused. So,
yeah, well, we've seen trademark infringement cases for, I'm not saying they're Michigan operators. I don't think they were, but in other states, we've seen folks try to make products that look like Skittles or Nerds and market them in that way. So, it's important to understand, if you're trying to make your product look like something else, not only are you going to commit a rules violation, probably you're going to get sued by whoever's trademark or product you're trying to use. So don't do that. Come up with something original.
Yes, definitely. And so the other labeling requirement that has been added, so you always had to have an expiration date. The MRA has clarified that after the expiration date, the product must be destroyed. So this is different than, your products in grocery stores and stuff where, they have an expiration date, but, the stores can still sell them just on like a fire sale or whatever. Cannabis licensees cannot sell the product after the expiration date has passed. And the expiration date also needs to consider the packaging of the product. So, how long the product is going to last based on what it's packaged in, the type of sealing and air issues that might come up in that, and the customary conditions encountered by the edibles from product production to sale. So I think what they're trying to get at is, temperature variations and where they're going to be stored and things like that could affect the life of the product.
Yeah, great points. Let's move on to declaratory rulings. So this is an entirely new rule set, and I imagine this concept's going to be a new one for probably a lot of folks on this call. I know it was new to me in this space, and I think it's a really welcome addition to the rules. What a declaratory ruling is essentially trying to get a binding opinion from the MRA about some sort of actual or hypothetical state of facts, and how the various body of law would apply to those types of facts. So it's not going to apply to a pending disciplinary proceeding or enforcement issue. So you can't say, hey, I did something wrong. Is this going to be a violation of the rules, and try to, get around the disciplinary proceeding with this process. But instead, this is really going to be helpful, I think, as folks are looking at the rules or the statute and thinking about interesting and creative ways to innovate and create new business processes, and thinking about how the law is going to interplay with those and whether or not what you're looking to do is going to constitute a violation of the rules before you do it, right? So we're talking about getting an opinion before you've done something most of the time. So this is common in other areas of administrative law. And now we have this approach here to create essentially a binding legal opinion from the MRA. And I think that's a good thing. Generally speaking, this doesn't stop folks from asking the MRA questions. You could still reach out, and I'm sure that the folks from the MRA on this call encourage everybody to reach out with compliance questions. This is going to be, I think, really important for more or less new processes that don't neatly fit in with the current rules, and that's not a fault of the MRA. Any lawyer, anybody, it's impossible to just write a law or a statute that covers every single conceivable scenario into the future. We all try, I think, and I think the MRA and legislature tries really hard to do that, but it's not possible to write and contemplate every single exact scenario. So now you have a formal mechanism. If you need a binding opinion before you start investing a bunch of money and try to change a process that maybe doesn't fit neatly in the rules or the language, now you have a way to get a good, solid, binding, definitive opinion on that. So that's declaratory rulings. Let's talk about everybody's favorite or least favorite topic now to kind of wrap things up on our presentation: disciplinary proceedings. Lauren, how are people going to get in trouble?
Okay, so the new rules I know everybody's excited about this, but the new rules say that, the MRA can take disciplinary action against a licensee for a couple of new things. Employing an individual who's been excluded from employment at a marijuana business under Rule 420.808A, and failing to remove from or attempting to add to the ownership of a marijuana business, an individual has been excluded from participation in a marijuana business under the same rule. So denial of a license rule has also been added as an option for penalties, and that's a pretty significant penalty. So it's definitely something you want to be careful about, because if you get your license renewal denied, you can really get yourself in some serious trouble, especially if you have a bunch of product and everything that you're going to have to deal with. So a person may be excluded from employment or participation in a licensee based on a finding of a violation of the NFLA, the MRTMA, or the rules, which could negatively impact public health and safety. The MRA kept this one pretty broad, so I think they're trying to stay flexible based on whatever issues might come up with certain individuals. And there's also going to be, I think, an actual exclusion list. I think this has been discussed before, but it sounds like it's going to be put together by MRA, and that's going to be what you'll have to consult to make sure that you're not employing or adding anyone that you're not allowed to. But it's also going to be that if you're listed on an exclusion list from another jurisdiction, so if someone is listed on an exclusion list in California, and the basis for being on that list would also be grounds for exclusion in Michigan, then you're also going to be excluded from participation in a licensee in Michigan, even though you didn't do anything in Michigan to cause that exclusion. And the big one, this isn't a new thing, is distribution of a controlled substance to a minor. This has always been a big issue for MRA. It's always going to be a big issue for MRA, and it's not something anyone should be doing anyways. So hopefully nobody really has an issue with that.
Yeah, and that one is actually the the distribution of a controlled substance to a minor that's disqualifying by the statute, right? So the MRTMA doesn't disqualify folks for most criminal convictions, but you are disqualified from holding an ownership interest in a licensee if you have a conviction for distribution of a controlled substance to a minor. So MRA doesn't have any discretion on that one. So great. That's it for our presentation. Let's turn it back to Angie. I think she's got some polls for the audience here.
Thank you, Lauren and John, for an amazing presentation and for all of the information you have provided. If you would like to access this presentation at a later date, you will be able to find the recorded sessions on the MRA's website at michigan.gov/MRA within a week's time. Before we break out into the Q&A session, please take the next few moments to answer the poll questions that are about to be, that you'll see pop up in a second. On your screen. You may also use these next few moments to post any questions that you may have in the Q&A box. Once we have gathered your feedback from those poll questions, we will move into the final portion of the presentation where Lauren and John will answer your questions directly.
Angie, you're on mute.
Sorry. All right. So at this time, we will open the floor up for Q&A. So please send us any questions that you may have. If you have not done so already, if a question you have submitted does not get answered or you think of something later that you need to follow up on, please feel free to submit those questions to our social equity team at MRA/socialequity@michigan.gov.
Great. So there's a couple that came in about Class A micro businesses. The first was, can they deliver to homes and designated consumption establishments? The answer is yes. That is something that Class A micro businesses can do. You'll want to look in the marijuana operations rule set for all the requirements that apply to delivery of product for marijuana sales locations, which would include the Class A micro business. Michael asked a question, can the Class A micro business licensee meet all cultivation requirements, but only execute on their access to the supply chain? In other words, can they forego actually growing and only resell products purchased from processors? The answer is yes, but you wouldn't have to build out your cultivation side if you're never intending to actually cultivate. But I have a hard time understanding why you would pick the Class A micro business license for that type of an operation, because the retailer license is cheaper and it would allow you to do that and also sell flowers. So if you're not going to cultivate, it wouldn't make too much sense to me to get a Class A micro business license. You would, ideally, I would think just get a full-on retailer license because it lets you do more and it's cheaper. So that makes sense to me. One more micro business license, and then we've got some labeling questions here too. Can the owners of a micro business operate a consumption lounge in an adjacent building? The answer is yes. That's absolutely allowed. And I think that probably makes the most sense for a designated consumption establishment to be adjacent to or very closely located to a micro business, Class A micro business, or a retailer. You have to keep in mind, you have to meet all the requirements for licensure for both different types of licenses, right? Not just your micro business or Class A or your retailer. You also have to meet those for the designated consumption establishment. There are rules that come into play as far as having separate entrances and exits between those two different types of licenses. So as long as you comply with all those, you have all your other approvals in line, absolutely, that is allowed. Lauren, there's some questions here on labeling.
So it looks like one of the questions is whether the labeling requirements and expiration dates apply to flower or just edibles. The expiration dates are specific to edibles. Flower, you're probably going to be limited anyways based on the freshness of it, because people aren't going to want old flour, but it's not specifically referenced in that rule, so that doesn't apply.
Great. Couple questions just generally about changes for secure transporters or safety compliance facilities. I mean, it's hard for me to answer a question, are there any changes? The answer is yes. There's only two of us here, and we don't have 20 hours to go through like the 200 pages of rules. So, the answer is yes. We've highlighted what we think are, the most significant changes across the board. The safety compliance facility rules are incredibly technical and complicated. I can't get through all of those here with you today. That's one where you really probably need to talk with your own attorney and start working through whether process changes are needed in response to the rules. And if you're an existing safety compliance facility, probably want to be talking with the MRA about what changes are going to be needed. Same thing with secure transporters. You'll want to talk with your own attorneys about every single different rule change. This is not an exhaustive list here, folks. We can't do that. I can't turn 250 pages into a 40-minute presentation. Wish I could. Not possible. If you have a specific question about a process, I'd love to try, but we just can't. There's just not enough time to be able to cover every single discrete change in the 200 pages.
Right. The next question is asked whether the rule that says the agency has to publish a public list of these excluded persons exists. This person wasn't able to find it. I do not believe that it is available yet. They are going to create one though.
Yeah, it doesn't exist yet. And the reason why is precisely the reason why that rule has now been promulgated is I know MRA had concerns about making sure there was a due process requirement satisfied prior to placing somebody on that excluded employees list. So this rule in 42808A for the excluded employees provides that due process requirement for MRA to put folks on an excluded employees list. So there isn't one yet. I would imagine the folks in MRA enforcement may be looking at that for certain individuals here at some point in the near future. Lauren, I think you had touched on, what happens for applications that were pending, with the new rules. I know we have some. Felicia had asked what the new rules in place. Is it another step 2 application drawn out, or do I continue to use the one that was sent on
I think she's talking about the form.
Yes. So
which I don't know that there's that many changes to the step 2 application form, but the easiest thing to do is always pull the most current form off of MRA's website. Because they're going to have the most current form on there, and then you don't have to worry about whether you have the updated one or not.
And if you already have filed a step 2 application, you'll want to talk with your application analyst at the MRA, and I'm sure they'll let you know if you need to use updated attestations for a pending application. Got another one here. With municipalities having so many different criteria for adult use applicants, is there a central resource that applicants, attorneys can view that lists the requirements of all municipalities that have opted in? No, sorry, doesn't exist. There's 1,700 municipalities plus in the state of Michigan. If somebody
wish there was.
if somebody wants to do the work and create that, I would probably pay a subscription fee for it. So it's a business idea for somebody, but the answer is no. I mean, that's as if you're an applicant or if you're an attorney working with applicants, that's a huge part of what we have to spend our time on is looking at the discrete ordinances for each individual municipality and complying with all their various different requirements there. Next question, will MRA be working with municipalities to help them understand social equity? Yes, I'm aware the information is on the website, but as a social equity member, I find myself explaining social equity in my license type to various municipalities. That's something I think you want to reach out to MRA and their social equity team after. So
Yeah, I think that's something that's going to vary a lot municipality to municipality too, because I think most of the time MRA does try to explain that stuff, but it's whether that's high on the municipality's priority list to seek out that information.
Next one, I know, Lauren, I'm sure we can knock this one out. The authorizing resolution that's required as part of the pre-qualification application. What is required? Is there a template? So the MRA doesn't have a published template, but this is asking effectively whoever is signing on behalf of the company. We need, what is giving them the authority to sign on behalf of the company. Usually it's a simple piece of paper, 1 page or 2 page that says, we're the members of this company. We're allowing Joe Smith, Jane Smith to sign and submit all applications to the Marijuana Regulatory Agency on behalf of the company. It doesn't need to be tremendously complicated.
Yeah, it's based on your operating agreement too. So if your operating agreement already has like a manager that's authorized to sign, the manager is authorized to sign an authorizing resolution as well.
Pamela says there needs to be workshops on how licensees and municipalities can work together in the process because they can become adversarial. I will tell you, I participated in a municipal education video with a number of other municipal attorneys and stakeholders that the MRA produced last summer. I know it's on the MRA's video library on their website. Forward that to municipal officials. Look, you're always going to, if you're a private business and you're being regulated by a government agency, there's always tension that's going to exist. So you can't make that zero, but there are some informational resources out there to try to make things easier on that piece. Christian, can a building owner lease to a marijuana company if they're under a mortgage? That's going to depend on the specifics of your mortgage. It's not something I can give a blanket answer on. You really will need to talk to your own attorney on that, and the landlord will need to consult with their own attorney on that question. Under the new private corp disclosure rules, are officers always considered applicants, even if they are less than 10% and do not exercise control? Yes. If you're an officer, you meet the definition.
If you're an officer, by definition, you exercise control.
So don't make them an officer if they don't exercise control.
Yeah.
Can you use a pole barn garage that's on your property to grow in? Probably not, but you'll need to talk with your municipality. That's going to be very specific to your municipality. Most municipalities don't allow businesses in residential zone districts. If that's the scenario that arises, probably not. If it's ag and the municipality allows it, maybe. So that's going to be really specific to your municipality. Speaking of delivery service, I was recently told by a municipal attorney that the municipality opted out of AU and therefore there was a prohibition of adult use deliveries within the boundaries. That's incorrect. I'm not aware of any way a municipality can prohibit delivery within their boundaries. I think that's wrong. Whoever gave the municipality that advice is incorrect. That is not something that I've ever seen. And in fact, the statutes contemplate secure transporters and other facilities being able to travel through municipalities. If municipalities try to do that, I would think whatever delivery service is trying to deliver to that municipality may end up in some kind of litigation on that question. But if I open a Class A micro, can I own other licenses such as retail, secure transport, or grow only? I don't believe so. I think the answer is no. I know the answer for a fact is no with respect to the regular micro business license and also with secure transport or safety compliance facilities. 99.9% the answer there is no, and you can only hold one Class A micro business at a time. So 99.9% sure the answer is no, but that's one I don't know the answer to with 100% certainty off the top of my head. Lauren, is it best to fill up the app by yourself or with an attorney? Your thoughts?
So I would say you can, especially if you're a little bit more limited on funds, you can fill out the app yourself initially and then just have your attorney review it to make sure everything is filled out correctly, that might save you a little bit there.
Yeah, I mean, you're not required, MRA doesn't require you to have an attorney through this process, right? So you're
No.
not required by the MRA to have an attorney, but certainly there are things that are going to come up undoubtedly in the structuring and formation of your business that are going to have legal consequences. And particularly if you're trying to organize a business with multiple different individuals that are going to have an ownership interest, there's definitely the prospect for legal disputes to arise, right? So it probably does make some sense to have an attorney help you with those pieces, making sure that your application is complete. I know myself, and there's a lot of other attorneys that do a lot of this work, Lauren, plenty of firms across the state do a lot of this application work, not because we're trying to make things more complicated on folks. Our job is to try to make things as smooth as possible with the MRA. And I know a lot of folks have time sensitivity. So with an attorney, you get the expertise of them having done this before for other clients and understanding what is needed through the application process. But it's not a requirement, whether it's better or not. Obviously, this is what I do, and Lauren, this is what we do as part of our living. So we're very biased, and would tell you, yeah, you probably ought to have an attorney, but not required by the MRA. They will accept your application and process it in the same way, and you'll get treated the same way as any other applicant, attorney or otherwise. Last question, to follow up on my previous question, can I open my business as retail and then upgrade to a Class A micro, or simply relocate and then open a Class A micro? So this is really complicated. This is really, it's going to be very specific to the municipality and what the ordinance and restrictions are, what the zoning requirements are. I can't answer this question as a blanket statement. That's one you're really going to need to talk with your attorney about, especially if you're thinking like 4 chess move steps ahead on what you want to do with your licensing. I can't give you a blanket answer on that, Reggie. I'm sorry. That one is going to be really specific to your municipality and what your structure is, and what you're looking to accomplish out of that location. Sorry. So that's all. I think I'm surprised we knocked them all out. We did pretty good too. We were right at the hour mark, right? So.
All right, thank you everyone for joining us today for our business workshop, and a special thank you to Lauren and John for sharing your knowledge, expertise, and passion for helping others. To our viewers, we appreciate the engagement that we continue to receive with these workshops, and hope that you continue to find the information that we present on each month beneficial in your future business ventures. Please stay tuned for more opportunities to meet with industry and professionals on an array of topics in the future. Until next time, have a great afternoon, everyone.